Viewers, Aam Aadmi Party founding member and one of its impresarios, Sanjay Singh, is about to be released from Tihar jail. We're awaiting news. We are told that that could happen anytime now. It hasn't as of yet because the order from the court apparently hasn't still reached. That's what we were told as of last. But you can see the live pictures from Tihar jail, a huge assembly of AAP workers. Their topmost leaders are waiting there. The police have also, of course, set up a cordon sanitaire so no one sort of mobs Sanjay Singh when he comes out. But nonetheless, viewers, expectations are high. And as is to be expected, the AAP is rejoicing. The party has declared this moment to be an unreserved triumph, a sign that the Enforcement Directorate, the BJP's alleged pitbull, as the AAP calls it, has orchestrated a fake case against the AAP. Viewers, is the claim. Now let's quickly test if this is indeed the case, viewers, whether the AAP can claim vindication. Here are some hard facts that need to be carefully considered. Hard fact 1. The Supreme Court confirms that there is a money trail of 338 crore against Sisodia. Now, Sisodia, viewers, was accused, number 1, in this particular liquor policy license excise alleged scam. And with the Supreme Court itself coming out and saying that yes, there is a money trail, it becomes difficult, viewers, for the AAP to claim that the relief to Mr. Sanjay Singh is a larger sign of the ED's alleged, and I can only use these words with an underline, alleged complicity with the BJP to fix the Aam Aadmi Party. Then there is another hard fact. And remember, viewers, I always bring these hard facts to you so you can get closer to the truth. And there are unbiased hard facts. The second one, the court has denied bail to Sisodia at least 5 times and Vijay Nair at least 2 times. And the ED has always demanded the extension of bail. Hard fact 3, the court takes cognizance of charge sheet prima facie, accepting the ED case, at least at face value, at least the fact that there is enough material evidence to begin a trial. We can't ignore this. Hard fact 4, 4 witnesses have deposed against Delhi Chief Minister and AAP Supremo Arvind Kejriwal. Hard fact 5, 2 accused turned approvers and government workers have deposed against Manish Sisodia. Hard fact 6, the Enforcement Directorate case is built on technical electronic evidence like WhatsApp chats, IT data, apart from, of course, depositions of witnesses, viewers, and approvers. Of course, this is not to say that the Enforcement Directorate has nothing to explain. In fact, its credibility also rests on its ability to convince on some crucial hard facts or data points. Number 1, viewers, there is a perception building of overwhelming bias against opposition, as 115 opposition leaders have been persecuted or prosecuted rather by the Enforcement Directorate versus just 6 of the BJP in a considerable span of time. Since 2014, 25 opposition leaders who crossed over to the BJP, 23 of them have got a relief or a reprieve in ongoing probes against them. Questions over reliability and credibility of 2-star witnesses who donated to the BJP also remain. And therefore, viewers, we need to ask certain questions tonight. The first question I'm going to push is at Piyush Joshi, political analyst and of course sympathizer. Suman C. Raman, Dr. Raman is also there with us. We're just expecting Piyush Joshi in just a few minutes. Sanju Verma stays on. She is the BJP's national spokesperson. Let me begin with you, Dr. Suman C. Raman. Yes, the AAP can feel very relieved. It can express triumphalism. But does that mask the fact that it has no case to answer? Yes, it has saved a big face, but it's in danger of losing the credibility race. That's my fundamental question to you, sir.
how is it in danger of losing the credibility race? If anything, the court statement that there is no money that has been recovered so far is a damning statement. I know that it is not a judgment, but the fact that the Honorable Supreme Court actually said where is the money in a money laundering case, I don't think there can be anything more damning than that. The case has been going on for months and years. Every time somebody is brought in, they for first they refuse to implicate these people. After that they are arrested. Once they are arrested, they give a statement against these people, and after that that becomes an approver statement. There is the same pattern has been followed. Mr. Kejriwal put it brilliantly when he made his own defense in court. So I think that we have to understand that for a money laundering case there has to be money. So today, the Additional Solicitor General says we have found the money trail, but we have not found the money. Maybe because the money has been spent. Rahul, I mean, I don't know what to say. I mean, when this kind of arguments are going on, there is very little which we can say. But I think the people are watching all of this. People are watching how Mr. Sisodia is in jail for over a year now, how long Mr. Sanjay Singh has been in jail, Mr. Satyendra Jain has been in jail for 2 years. And the point is, why would the Enforcement Directorate say that they have no objection now? You tell me. It's basically because these things are not playing out in the public eye in the manner that it was hoped. The arrest of Mr. Kejriwal across, I don't look, it's not about what people think of in Delhi. It's about what people think about the arrest of Mr. Kejriwal across the country, and not just in India.
So it's not playing out the way the BJP thought it would? Okay. Viewers, there are a lot of assumptions, of course, in what Dr. Sumansi Raman has said. It's the courts that are denying bail, not, of course, the BJP. But let me bring in Sanju Verma. She wants to get into the conversation and rebut Dr. Raman. Go ahead. Yes.
I want to make it very clear that the Enforcement Directorate was an advisory body way back in 1964. Since 2003, it has the powers of a civil court. The income tax is a statutory independent body. The CAG is a constitutional body. So my first argument is this: let the law of the land prevail. Let us stop undermining the credibility of our investigation agencies. Let us stop damning the probe agencies. My point number two, fine, people have started jumping and saying, oh, Sanjay Singh is going to be a free man now, because guess what? He's innocent. No. Anybody who has an iota of common sense and knows even this much, teeny bit about India's jurisprudence knows if you're out on bail, it does not necessarily mean you're innocent, nor does it mean that you're guilty. It simply means that for the time being, your custodial interrogation is not necessary, hence you're out on bail, but a final verdict is awaited. So let us not try and say कि भाई संजय सिंह राजा हरिश्चंद्र का दूसरा अवतार है, क्योंकि ऐसी बात नहीं है. My third point, saying that the Enforcement Directorate, why is it only targeting a certain set of people who are anti-BJP? This is the same argument which was given by Abhishek Manu Singhvi, no less, in as recently as April 2023, in front of the CJI, Justice Chandrachud. And what did Justice Chandrachud tell him? Abhishek Manu Singhvi put up the same figure. 78% of the cases are against, the opposition parties. Only 47% of the cases are against ruling party members, blah, blah, blah. And CJI Chandrachud castigated him in no uncertain terms, saying, if you have any specific grievance, do come to us. Do not make general statements. Are you trying to tell us that politicians should be treated differently, or that they belong to Mars or Jupiter? The fourth and most important point is this. The same Sanjiv Khanna who agreed to give a bail to Sanjay Singh is also the same Justice Sanjiv Khanna who has recently, as October 2023, along with Justice S.V.N. Bhatti said, as Rahul Shivshankar pointed out, in the liquor policy scam, a tentative money trail of rupees 338 crore has been established. You started lambasting and lampooning and undermining Justice Sanjiv Khanna in October 2023. But when Justice Sanjiv Khanna gave a bail to Sanjay Singh, you started saying sab changa si. Basically, the entire cabal on the other side believes believes as long as the judgment
Doctor.
is in their favor, all is good.
Yeah,
I
yeah.
need to
No,
rebut.
can
Yeah,
I
yeah.
please finish, Rahul?
Okay.
I don't understand why I'm being heckled repeatedly.
30 seconds, please. 30
Yeah.
seconds, finish. Yeah.
And in 30 seconds more, what did ASG Raju tell the court? He said that they will provide ample proof to showcase how via Havala funding and how via unaccounted cash money was spent to the tune of over 40 crores in the Goa elections, and
Okay.
this money is dirty money, which is the byproduct of the Delhi liquor scam.
Okay.
Why are you quoting SV Raju?
Visuals,
selectively?
viewers.
Two
I
quick
need
points.
to draw 1 second. I just need to draw viewers'
I need to
attention to
rebut.
what's happening on screen. We are told that Sanjay Singh is going to exit Tihar jail any moment now. Pictures of some action outside that gate. Now, Dr. Raman,
Yeah,
the SC has confirmed a money trail
First
of
all,
rupees 338 crores.
No, that's exactly my point. The 338 crore that the Supreme Court was referring to as a money trail refers to the profits made by these companies. By no stretch of imagination can that be taken as a money trail, and that is the simple
No.
reason. 1 minute.
One second. Let him finish. You can rebut him.
Let me finish.
Let him finish.
Now,
You
when
can
I
rebut,
speak,
please.
you can interrupt.
Sanju
But
Verma,
when
let
she
him
speaks,
finish,
nobody
then you
should
can
interrupt.
rebut, please.
How is it fair?
Okay, go
1
ahead.
minute.
Dr. Raman, go ahead.
1 minute. Yesterday, did the Supreme Court actually say, couple of days ago, did the Supreme Court say money has not been found? Did the Supreme Court say it or not? The 338 crore that was being referred to on that day was called as quote unquote proceeds of crime, which was the profit which allegedly was made by these private players. By no stretch of imagination
But tell
can that
me
be
something,
taken
Dr.
to be
Raman.
proceeds of
If
crime.
you
I'm
no,
sorry.
hang on, this is a circular argument.
It is not. It is our
So what's
official
your
government
line?
policy.
Yeah, okay. Let Ms. Verma respond to you,
provide a
and
service to the
I want to
government
make a
and they
point
get
right
some money
after
out
that.
of it.
Okay,
Nobody
1
commits a
second.
crime.
Okay, 1 second. Yes,
Rahul?
respond. Yeah.
Rahul, I want to again reinforce in front of your audience. In the Delhi liquor policy scam, why has Manish Sisodia not been given bail? Why is Arvind Kejriwal still languishing in the lockup? Why has Satinder Jain not been given bail? Because there is actually a liquor scam. It's not a figment of the BJP's imagination. Custodial interrogation of Sanjay Singh was not required at this point in time. It is the Enforcement Directorate which actually said we do not oppose the bail being granted to him by the court. So my third point is this. How on earth did Sumansi Raman believe or interpret that, when the Supreme Court said 338 crores worth of money trail is tentatively established, the Supreme Court actually meant profits. The word profit was not used by the Supreme Court.
I'm sorry.
It clearly said money trail has been established tentatively.
Okay,
Now,
1
please
second.
shut up.
1 second.
Please shut up.
1 second, please. 1 second. Let me just step in here. Viewers, it is a bit of a circular argument. 1 second. Listen to me. Please, let's have some peace on the show. Please, gentlemen, please, I beg you both. Let's not cross the line.
This man lied.
1 second, please. Okay, I'll lower everyone's faders. I'm counting till 3. 1, 2, 3. Faders down. Okay. Now, viewers, I just want to say one thing. A bench comprising of Justices Sanjiv Khanna and SVN Bhatti said, one aspect regard to transfer of money, rupees 338 crores, is tentatively established. We dismiss the application for bail of whom Mr. Sisodia. Now, what was this 338 crores? It was profits that accrued to these liquor companies. It was proceeds of crime. Now, viewers, the case is that a bunch of money was paid in kickbacks so that these particular companies could do profitable business much above returns that were probable. And therefore, viewers, all this money, therefore, because it arose out of an alleged bribe, would obviously be the proceed of crime. Therefore, viewers, there is a money trail. Now, Dr. Raman, you can come in. You can say, what is the issue?
Ask her to apologize first, Rahul.
For what?
I said these are the profits of these liquor companies which arose as a result of a policy of the Delhi government. How can it be proceeds of crime?
Of course,
This is on a
no, hang
policy-
on. So, Dr. Aman,
Unless
Dr.
you
Aman,
establish
no.
right
I'm sorry, you've got it wrong here. There is a very firm definition of proceeds of crime under the Enforcement Directorate Act. Now, I can't have these people shouting over each other. 1 second. Sanju Verma, can you establish why we are talking about a money trail? The reading that one has from the documents is the following, that if a company starts a business and that business is started with unaccountable wealth, then any money that that business generates is treated as a proceed of crime. That is the technical definition of proceeds of crime, at least in one aspect. Now, Sanju Verma, quickly rebut Dr. Raman on this issue.
Rahul, I want to just point to one very important thing. I don't want to undermine anyone, but sometimes I'm appalled that I have to debate with people who are the educated illiterates. What did K. Kavita say during her deposition? What did K. Kavita... Rahul, I refuse
Can we
to
stop
debate like
speaking
this.
over each other, please? Dr. Raman, this is not right. Can we stop speaking over each other? I'll give you an opportunity to rebut. Let her finish first. I'm now losing my patience.
Thank you.
Please don't reduce me to some sort of school principal here. Please. You're not children.
Thank you.
Yes.
Rahul, what did K. Kavita say? Post her arrest. Rather, why was she arrested? She categorically said that she has invested 65% stake in Samir Mahendru's Indospirit, 32.5% through her so-called confidant, who's now turned an approver, Arun Ramchandra Pillai, and another 32.5% through a gentleman called Prem Rahul, very close to K. Kavita. And she said that she was allowed to invest in Samir Mahendru's Indospirit in lieu of 100 crores worth of kickbacks which she gave to Arvind Kejriwal and company. She has specifically named Arvind Kejriwal. So my first point is this, that an accused, when he or she is naming and shaming someone, is it evidence? Yes, under the Indian Evidence Act, that is permissible evidence. Are you saying K. Kavita is lying? Are you saying Dinesh Arora is lying? Are you saying Amit Arora, who named Kejriwal, is lying? Are you saying the former personal secretary, C. Arvind, of Manish Sisodia, who's also named Kejriwal?
Well, they are saying that. They are saying that. They will say that. They will say that because that's their way of undermining the case and they're entitled to do so. And now, one second. Let me just bring in Mr. Srivastava. Mr. Srivastava, you see, there is also technical evidence. There are accused who've turned approvers. Government workers have deposed against Manish Sisodia. It's not just those two people who've been taken into the BJP or who were raided and then coughed up money. That does look a little grey, I have to admit. I don't know how that happens, but put that aside for a few moments. There's a whole bunch of other evidence also. Mr. Srivastava.
Whole case is fake, concocted, fabricated, resting on the injunctions, conjectures, surmises, assumptions, hearsay. One person said to somebody, other person said to somebody. There is a money trail. I can prove that. One money trail is there. The money trail starts from Mr. Sharat Chandra Reddy, who bought 60 crores worth of electoral bonds, turned an approver, got a bail on a minor health issue of a waist pain or something like that, and becomes an approver.
And
let me ask 60 crore worth
let
of
me
bonds
ask the BJP spokesperson to respond to you. That does look colored, and I have pointed it out in the graphics that are appearing on the screen. I have talked about questions of the reliability and credibility of these two star witnesses who donated to the BJP. Can you respond very quickly?
Rahul, I'm the last person to shove difficult questions under the carpet. My limited rebuttal is this, and I've said this on a zillion debates. Yes, Sharat Chandra Reddy turned an approver, but why section 195 of the IPC, and anyone who knows law knows, why section 308 and 340 of the CRPC, simply turning an approver does not mean that the accused's sentence will be commuted. It simply means that yes, he has admitted that there was wrongdoing, but corroborative evidence needs to be needed to ensure that the so-called case is brought to fruition. So Sharat Chandra Reddy has actually inadvertently, by turning approver, admitted that yes, he was part of the liquor policy stand. Does it mean that he will be given a free run, he will get bail and life is going to be kosher for him? No, because the CRPC provisions say that even after he is deposed and turned approver, corroborative evidence will be needed to bring the liquor policy case.
Okay, very
to
interesting.
fruition.
I'll leave
Yes.
it at this, US. Very interesting, because I read somewhere in one of the newspapers that there was a plea bargain where his culpability is being waived off. So Sanju Verma even read that the deal is that he will not be held to his crimes. I don't know, viewers. Obviously, I'll have to go back and check this. So I am only saying this because I read it somewhere. It could be wrong. I will come back to you next time we debate this issue. I'll take a very short break. We'll be right back.